Receive.
May it please the court, my name is Don Conwell, and I represent the petitioner, Sin Yo, who is seated here behind me. There's really not a dispute here that Mr. Yo, as the court-appointed receiver, has absolute judicial immunity from suit and from liability for acts conducted within the scope of his authority. The challenge here.
When you steal something, is that within the scope of your authority? No, it hurt the trial judge in this case.
No, but you can't just rely on labels, because what they said in their brief is steal. But when you look at the allegations of the Third Amendment complaint, look at, for example, conversion, and they piggyback onto that civil theft. So that's the quote stealing.
Yeah,
They said that I'm sorry.
You had about 5 counts to deal with by the time you.
Right, yes. And so look at what the conversion is that they pled. They said that Mr. Yo made payments to his wife, to Mr. Kim's wife. Well, if you look at the appointment order, that's what it says he's supposed to do. It says Mr. Yo made payments of his receiver fee to himself. And that's part of the operational cost of these 4 commercial properties. He calls that conversion, and he calls that a theft. So he did what the order tells him to do. They're simply throwing a label on it and calling it theft and saying, obviously, you don't have permission to commit a theft. So the issue really comes down to, are these allegations of wrongful acts, and are the allegations on these 4 or 5 different counts made against Mr. Yo as the receiver for acts that he was.
Aren't you getting into the substance? Is there a standard on certiorari that is going to be detrimental to your review at this level? You can do all this at the end of the case, true or false?
I think false, because it is immunity from suit. In the case of judicial immunity, that's considered a common law absolute immunity from suit and liability. If it were just liability, then it would fall in the category of this insurance case that they cited from the Florida Supreme Court in 2012.
The Fuller case, I think you cited the Fuller.
Fuller is the first DCA case. The Fuller case says there is that this is reviewable by certiorari when you file a motion to dismiss, and there's judicial immunity, or in the case of someone who's not a judge, it's called quasi-judicial immunity, but it's still absolute immunity from suit and from liability. So if it's immunity from suit, then being forced to proceed with the suit deprives you of that immunity. So that's why there's common law cert to review such an order. Normally there would not be. In the case of sovereign immunity, the Supreme Court said in 2012, you got to wait till the end of the case. But that's not the case with judicial immunity. And I cited a number of cases that say exactly that in my initial brief and in my reply brief, that the proper remedy here is a writ of certiorari. Now,
before we get to that point, Mr. Conwell, would you agree that when a receiver steps outside the authority that's granted by the court, because in this case, he was appointed by the court to serve as a receiver, and if he does things in a personal capacity and not as a receiver, he cannot blame.
Yes, and so I was trying to think of an example of that. If, for example, he had.
Let me go down the next step. So here, based on the allegations and the complaint, and as you know, in the writ of certiorari, as Judge Valenti said, that's an actual year. You look at what the allegations are, and the allegations are pretty significant. He actually has taken steps to do things in a personal capacity, taken funds, taken things, whether you call it conversion, whether you call it theft, whether you call it misappropriation, misfeasance, all of these have been alleged in the complaint. If these allegations are, would you agree that this will take it away from the protection granted to the co-filers.
Right, but that's not what is pled. If you look at what they actually plead in the complaint, I think it's their third amended, but it's just I'll call it the operative complaint. They say Mr. Yo as receiver owed a duty and breached that duty. Count one. They say that Mr. Yo as the receiver owed a fiduciary duty and that he accepted that fiduciary duty by accepting his appointment. Count two. Count three, that Mr. Yo was unjustly enriched by receiving payments from the husband and the wife pursuant to the receivership order that appointed him, which expressly says they're to pay it. So those are all acts as receiver, and the same with conversion.
Beyond that, wasn't there developed in the record that he went beyond that by taking the funds and applying it to his own personal use aside from his role of receiver? Isn't that also alleged in the complaint?
I've got the First Amendment complaint right here. There are these 26 wrongful acts. They don't say that. What they say is that in his capacity as receiver, he took money, and the biggest part of their complaint, so far as I can tell, has to do with the activities of Mr. Yo after November of 2014. November of 2014 was the date of a final divorce decree, because all this arose in the context of a divorce between Mr. Kim and his former wife. And that's where Mr. Yo was appointed receiver to basically manage these 4 commercial properties. And so in the context of those 4 properties, he continued to receive rent. I asked you to look at the receivership order, that order appointed him receiver. It says he will receive rents. The rents came to him at the direction of the husband and the wife, not him. He wasn't a collector. He just was to receive rents. When he received rents from these tenants at the instruction of the husband and wife, he was to use the rents for operational expenses, including his own receivership fee. Their argument, and I think this is what they're trying to plead in their operative complaint, is that once they were divorced, he had no obligation to continue doing that. But the fact is, those 2 parties, the husband and wife, continue to instruct the tenants to pay him. They continue to pay him. And from that money, he paid the operational expenses from November of 2014 until November of 2015. What happened in November of 2015? There's a termination order. And in that termination order, Judge Moody says the receivership is now over with. She doesn't say, as to all this money that you gave to the wife in the last year, this money that you spent on the property, the commercial properties, the money you paid yourself as receiver, give it all back. That doesn't appear in that order. What the order does say is that it looks like there's going to be another a month of rent coming in, and you were to continue doing what I told you to do in May of 2013 and pay the operational expenses. And Mr. Yo, if there are any receivership fees owed to you, you are to pay that from that money. That's when the receivership order, that's when the receivership ended. But most of his complaint, most of this alleged theft is for him, quote, taking that money for himself. Okay, that's what they call theft, paying his fee for the receivership.
So the fact that he never deposited those funds, this is what's alleged, into the escrow account, that in personal and business and commingled it with other monies and transferred it and took care of that. You're claiming that this was all done under the auspices of being a receiver?
So if you look at what they allege regarding the escrow account, first they allege that there was no escrow account. Then they allege that he converted by removing money from the escrow account. You can't make any sense of that. You've got to look at the substance of what was alleged. As all this conduct here alleged conduct by Mr. Yo regarding these commercial properties. And the answer is yes. This is not like some business deal between Mr. Yo and Mr. Kim unrelated to these 4 commercial properties, and he cheated him on the deal and he's suing him and he's asserting immunity as a receiver. That would be separate.
I think, Mr. Conwell, the disconnect is you're claiming because all of the allegations stem around him being a receiver, he cannot touch him. And to follow what Judge Valenti said, and I think you acknowledge the fact that if someone performs acts that are outside the receiver, do not get the privilege of that judicial immunity. And so the question is, in this case, based on this record, there's been allegations that he misappropriated, depositing into his personal business account. That's in violation of the order of the receiver. And so that, if that's allegation is true, then he's not being entitled to that immunity, correct?
And correct. And Judge Kazan, I believe that the way that is supposed to be handled is you go to the judge who issued that order and you say he's acting in violation of your order, and that judge takes care of that. Instead, you've got a termination order. None of this was ever said at that time. It was a full 2 years later before any of these allegations were made. So that's the way that's supposed to be handled. Not through these kind of allegations years later that Mr. Yo acted outside of his authority. But again, I think if you look at the allegations of the complaint, all of them are saying Mr. Yo, as receiver, did this. They say in their brief that they've sued him in his personal capacity. Those words don't appear anywhere in this operative complaint. They do say repeatedly, as to each and every count, as receiver, you did this, as receiver, you did that. Now, I've cited half a dozen cases to you involving receiverships where someone came in and said there was a misappropriation, there was a breach of fiduciary duty, there was all this, and the court said immunity, right? And why? Because you look at the substance of it and you can't do what he's doing, which is simply taking things that he did, the court orders him to do, and then just labeling it a conversion. And, as to the taking money out of the escrow and using it personally for himself, that's talking about his receivership fee. That's what he's talking about, is you paid yourself, I think it was $25,000. You paid yourself $25,000 out of the escrow account. Well, the order appointing the receiver specifically says he can do that. So I think you get rid of the immunity doctrine completely if you allow somebody to come in here simply with these labels to describe the conduct as something egregious. You maliciously, with criminal intent, et cetera, converted this money and you stole it. When in fact, what you did is you wrote a check to yourself to pay your receivership fee, or you wrote a check to the wife because it was money that was left over at the end of the month after the fees of operating the 4 commercial properties were paid for. That would eviscerate entirely the immunity doctrine if you could control that with your pleading by simply saying, these horrible things. Because now we're just like as Judge Kuzama is saying, well, are we kind of stuck with that? He said you stole, right? So no immunity. So even though it's immunity from suit, you have to go through the suit anyway. That can't be the law.
You didn't ask for rebuttal time, but I assume you want.
I'm sorry,
You want 5
I meant to ask for 5 minutes, yes.
Okay, you got a couple more minutes. You need to keep going.
Okay, well, one thing that I haven't talked about yet is the second part of the order, and that was involving the financial worth documents. And on that, this implicates the privacy rights of Mr. Yo. And, we objected on the basis, we moved for a protective order. They asked for financial documents going back 5 years when the sole issue is the financial worth of the defendant at the time of trial. So it's overly broad as to time. It also asks for financial documents of his wife, a third party. They haven't made a showing as to that. We asked for a protective order to prevent unauthorized disclosure to third parties and to prevent used for anything other than a trial on punitive damages, and that was denied. I believe that cert should be granted to review that order and to grant our motion for protective order. Of course, the main reason for the protective order is that he's immune from suit. Thank you.
I'll say 5 minutes.
May it please the court, my name is Daniel Nicholas and I represent the respondent Sue Kim. I'll first focus on the order that denied the motion, that correctly denied the motion to dismiss and the motion for protective order. This appellate court should not exercise cert jurisdiction and quash an order that correctly denied the 4th motion to dismiss for failure to state a cause of action without any leave to amend based on qualified, not absolute, judicial immunity based on the operative complaint that contains a punitive damage amendment where it's alleged against the Yo defendants and Mr. Yo individually, that's paragraph 6, individual, that he stepped outside his authority, at least 15 references to that in the complaint I counted, of a property that was never part of the receivership estate, it's non-marital property, and never escrowed as required by the court. The very court that authorized the lawsuit against Mr. Yo under the Barton Doctrine, the very court that in 2015 confirmed that the receivership had been effectively terminated by final judgment of dissolution when there were no more assets, but he refused to go away and kept spending my guy's property. Okay? Now, as a matter of cert jurisdiction to review a non-final order on a motion to dismiss for failure to state a cause of action, the general rule is there isn't. I cite the Supreme Court DCA law. The case I want you to focus on, though, is the 5th DCA case called DJR Atlantic versus Babong, because that case brings together the irreparable injury concept of non-final orders with immunity. In that case, the issue was whether the appellate court can review an order as to immunity, non-final order, based on the Graves Amendment, statutory immunity. Okay. First thing the appellate court said is non-final orders don't get cert review. Motions to dismiss, summary judgment, you don't get cert review. There's no irreparable injury, even if it departs from the essential requirements of law. Then they looked at sovereign immunity cases in Florida, a lot more extraordinary. The court said generally those are dealt with post-judgment as well because they're driven by disputed facts. That's Citizens Property Insurance Company case for Williams, we cited. And then the court noted under Rule 9.130, there's specific types of immunity that gets interlocutory review now. What are they? Civil rights immunity, comp immunity, and sovereign immunity. The body court said interlocutory review is now limited to those types of immunity. You can't use cert jurisdiction to avoid 9.130. The committee notes say, hey, 9.130 is not intended to abolish common law cert for extraordinary circumstances and extraordinary cases. This isn't extraordinary when you have qualified immunity. They know that 9.130 probably applies. So they're trying to get around it, filing a 4th motion to dismiss for failure to state a cause of action. The motion's disingenuous for 2 reasons. It ignores the record. That's the first reason, an 8-year record. There are 3 prior motions to dismiss in this case. First motion to dismiss, there's judicial immunity. You need to comply with the Barton Doctrine. Well, we go to the court, get permission to sue with a prima facie showing of liability. The court that entered the receivership said suing. They then file a second motion to dismiss based on judicial immunity. You need to comply with the Barton Doctrine. Said time out. You participated in this prior hearing. What are you doing? They abandon the motion, withdraw it, and answer it. They don't raise any judicial immunity. We don't hear about it again for about 8 years. What happens next? We start discovering theft. What do? We amend the complaint, add a count for conversion and theft. You know, lawsuits are about labels. Conversion and theft's a label. We add those counts. What are they doing? Another motion to dismiss is filed. What happens? There's a hearing on the motion. It's denied. Now, that order, I couldn't find it in the record, but there was a hearing. I cite the hearing date, it's in the record. It was denied. If they say that motion wasn't denied, I don't know what to say. It's denied. Because they didn't answer the complaint and they don't raise any judicial immunity. They play possum again for another 4 more years or whatever. What happens next? We get a punitive damage amendment. What? Based on what? Unopposed. They don't even respond to requests for admissions admitting to theft. Outside authority. What else? Unopposed affidavits. What else? Unredacted bank statements. We had to get a contempt order to get bank statements. There's the amendment. What do? They answer it. Great. They allege judicial immunity for the first time in 8 years. Fine. We reply to it. You exceed your authority. This isn't property part of the estate. What do? Another motion to dismiss. After 8 years, now irreparable injury. Where's it been for 8 years? Where was it in 2015 when the family law court entered an order confirming the receivership was terminated at final judgment of dissolution? There was no more marital assets for this guy to be controlling in any way. Paragraph 5D of the order authorizes relief as set forth in a motion to confirm termination against Mr. Yo. It's all there. Where have you been for all these years? Where were you at the summary judgment order when theft was found about paying your own credit cards? Isn't that irreparable injury? What about that punitive damage order? Isn't that irreparable injury? What about the prior motions to dismiss? Where's that been? But here's the biggest conflation, and I think you picked it up. They're conflating the concept of absolute immunity for judicial public servants with qualified immunity for a receiver that only applies if, air quotes, the receiver acts within his authority of a receivership property. One's absolute, one's qualified. And audaciously, they state in the reply brief, it's the same, that qualified's the same as absolute immunity. No, it's not. Absolute's for public service like you folks or county planning commissioners or whatever. This isn't absolute immunity. Absolute immunity by its very nature is based on the Barton Doctrine, which is a doctrine of qualified immunity. But call it absolute or call it qualified or whatever, theft is not an act for which anybody gets immunity. Give me a break. The trial court figured that out. That's why the order does comply with the essential requirements of state law, federal law, which has really no application and bankruptcy trustee overlays. And if you look at the complaint, it's all there. As a matter of state law in Florida, a receiver does not have judicial immunity if he acts outside his authority, that's what you look for in the allegations of the complaint, of a property that's not part of the estate when there's been escrow defalcation. We sue converted escrow monies, it's in there. When we comply with the Barton Doctrine, pretty neat. Doctrine of qualified immunity gets back to 1881, Martin v. Barber. It says, listen, if there's been a receivership, you got to go back to the issuing court to grant leave, to get leave to sue so they can determine if property's at issue or if he acted outside authority. It's qualified immunity. They're the gatekeeper. Florida follows that doctrine. We cite all the case law. Ocean Drive v. Book, 182 Southern 2nd, 782. I'm a bank attorney by trade. I quoted. It's based on a 1970 case by Murtha v. Stansky, another case we quote all the time. What does the case say? Black letter law. A receiver has no immunity if he acts outside authority. He can be sued for it. Here are the causes of action. Negligence, check. Malfeasance, check. What else? Breach of fiduciary duty, check. And even breach of contract, because everything in a way gets back to the receivership, but you can even sue for that if he's outside his authority. That's followed throughout Florida. We say asset recovery versus Cabrera, asset recovery versus Wright, DeSalma v. Ruda, Gomez v. Nichols, Florida. In Florida, we follow this doctrine. Asset recovery versus Cabrera. That was a cert case. Guess what? No jurisdiction, no irreparable injury to review qualified immunity. Also in that case, they noted that when you comply with the Barton Doctrine, it means there's been a prima facie showing of liability. The receiving court that issued the receivership court knew that. That's why they granted leave to sue based on their motion. Also, asset recovery versus Wright, that shows how you always defer to the issuing court in Florida. You have to go back. That's what we did. The remedy of all those cases, if there's an issue, the courts grant leave to comply with the Barton Doctrine. We did that. Or if there's an issue, whether you've alleged exceeding authority, they allow leave to amend, but not motion to dismiss with prejudice. Fourth motion, after 8 years, give me a break. After you've answered it, wow, I don't even know what to say to that. Why don't you file the motion on the eve of trial? It's just not correct. All that case law, by the way, was in their first motion to dismiss. They filed on us. You cited the motions in your motion case law that we based our complaint on. One Ocean Boca, I wrote the complaint based on that case. Don't know much more I can do. Federal law they cite, federal law. Why does that apply when there's a bankruptcy trustee overlay in federal law? But I encourage you to read it. There's a 2024 case I saw called Durbin that they ignore. It's a Middle District case of Florida that goes up to the 11th. They look at the federal overlay with the Florida common law analysis about the Barton Doctrine. It was looked at from a subject matter jurisdiction perspective initially as to whether there's property involved. You got to defer to the trial court as the gatekeeper. But then there's no immunity if you step outside authority concerning property of the estate. All federal law says that. The case they cite the Chua case, fascinating case. I agree. The court granted leave to amend to sue the receiver in Chua for actions outside authority. The plaintiff didn't take the leave to amend and challenged because he didn't comply with the Barton Doctrine subject matter jurisdiction. He could have amended and sued. Why they're citing that, I don't know. It complies with the essential requirements of law. Let's drill this complaint home because I'm ticked that 8 years later, I'm now here. Paragraph 11 is the operative complaint, the first operative complaint. That's the punitive damage amendment paragraph in this case. We allege in that paragraph 2 times he acted outside of receivership without authority and took my guy's property, converted property. With all inferences in my favor, that should get us home. Well, we do more. Paragraph 10, we list 26 items. Opening paragraph, all actions are without authority of the receivership. That's right from One Ocean Boca. Then 15 references to being without authority, right out of One Ocean Boca. That's after we allege in paragraph 6, we're suing him individually for his actions, as well as the case style. But then we go over some of these allegations we make in paragraph 10. And here we go. 10, it sounds like a Scrabble game. 10B, that Mr. Yo expanded all duties beyond receivership and authority. Next, he paid his own credit cards with my guy's money. That's not even in the receivership. What else? He paid his wife commissions with no receivership assets, my guy's money. Remember, after final judgment of dissolution, there's no receivership assets, and he's paying his wife? Come on. He paid my guy's ex-wife $80,000 with my guy's money. We now realize there was a relationship going on there. After final judgment of dissolution, there's no assets with my guy's money. They weren't even in the receivership. What else does he do? He converted monies. He commingled monies. He converted escrow. We didn't know the level of the escrow defalcation until we got bank statements through a contempt order. His first bank statements were all redacted. Wouldn't tell us. That's how we discovered all this. Well, what else does he do? He transfers monies between his personal account, his another account, loses 50 grand along the way of my guy's money. We allege that too. What else do we allege? He charges legal fees with property that's not part of the estate. He's not a lawyer. How can that possibly be protected? What they like to do is cherry pick some of the 26 allegations. And I love this. They said, well, wait a minute. He should get immunity. Remember, it's not absolute, it's qualified for paying bills. You know what? A receiver paying bills? Yeah, I think he should get some type of immunity for that. Nobody else would be a receiver then. But you know what? An attorney can't settle a case, take client money, and then put it in his personal checking account, transfer it to another checking account to pay his own personal bills along the way. That's escrow defalcation. That's theft. You get disbarred. Everything Mr. Yo did in this case is based on escrow defalcation. He shouldn't be claiming the benefit of immunity if you swipe the money to begin with not complying with an order.
We'll let you go on. You got about 2 to 3 minutes to wrap.
I'm about done, Judge.
Sorry.
So what we end up with is and those counts are, we call them the Yo malfeasance. They comprise count 1 for negligence. That's not carrying out duties. Count 2, breach of fiduciary duty over property that's not even part of the estate, outside authority. I can't say more than that. The trial court, Judge Nash, jumped on that as the basis for the punitive damage amendment. Unjust enrichment, paying yourself legal fees, really? And then we have conversion and theft, okay? If there's an issue with my pleading, we'd be glad to amend. Now, last point, motion for protective order. I appreciate that financial discovery is generally is limited for the case law they cite to the time of trial perspective. But these causes of action at issue are financial causes of action based on theft. We're entitled to know what you did with our money, where it went, how you spent it. Because we have bank statements now, we know it went to third parties. It's all fair game, and our discovery is relevant to that. And we would have shown that at the hearing on the motion for protective order if they would have bothered to show up. They never did. They didn't show up at the motion to dismiss hearing, didn't show up with that. So I guess they expect Judge Nash to grant their motions on a no-show. The last point is this. If theft is a judicial act for which the person committing the theft, the judicial officer, now gets immunity, I don't want my kids to go to law school. Thank you.
Mr. Conwell, you got 5 minutes.
I think the main point here, based on the panel's questions and his argument, is what was alleged. And let me just read some of this. Yo paid rental income, and I'm reading from the operative complaint that's on review. Yo paid rental income from the commercial property to former wife after divorce was final without authority or consent from Kim. I'm reading from paragraph 10. This is what he was ordered to do in the order appointing the receiver. Again, he's saying that after the divorce became final in November of 2014, that ended the receivership, but it did not. It continued until the order was entered in November of 2015, terminating the receivership. They continued to direct the tenants to pay the rent to Mr. Yo. He continued to pay rental income from that property to those two spouses. Next one, Yo paid himself approximately $25,000 in receiver's fees from escrow funds without authority or consent from Kim. It's in the order appointing him. And now he's saying, he calls that a conversion. Yo refused to pay operational expenses for the commercial property without authority or consent from Kim. So now he's saying you were ordered to pay operational expenses. You did not pay operational expenses. That's something within the scope of his authority as to what expenses to pay or not pay. And if they were in dispute, the order says he's to set them aside until such time as the parties agree that they could be paid out or the divorce court does something with that. Yo refused to set aside joint operating expenses for the commercial property for later reconciliations without authority or consent from Kim. These are all matters expressly covered in the order appointing the receiver. Again, I go back to this question. If you can just take the things that are directly within the scope of the order appointing your receiver and just, give them these labels and say they're a conversion, they're a breach of fiduciary duty, they're negligence, then there is no immunity. You can just throw immunity out the window because it's immunity from suit. And that's why it's got to be dealt with at this stage. Next, Yo improperly converted escrowed funds for receiver expenses without authority or consent.
1 second. Is this rebuttal or repeating what you said in the initial argument?
Well, I didn't read any of these to you.
Going into the rebuttal, go ahead.
Okay, well, I thought this was the main point he was trying to make. He was trying to say, hey, this is theft, and anytime you say the word theft, it's got to be outside the scope of the receiver's authority.
You guys didn't show up at the hearing on the motion to dismiss?
That was a calendaring issue, and
I mean, that's a yes or no answer, though.
yes,
Okay.
yes. So the judgment had entered an order without a hearing, but it was fully briefed. And so the judge was fully informed from the briefs as to what the legal positions were of the parties. And another argument he made in his response was that there was an order denying a prior motion to dismiss. There is no such order on the record. I've scoured the record. I filed everything that I cited to in my briefs. He cited everything that he did. There's no such order. This is the only order, the order that's on review here today. This is the only order from the lower court on denying a motion to dismiss. The issue was raised previously, but it was never decided. And then finally, he says that this is qualified immunity and not absolute immunity. That's just not what the Fulcum case says. That's not what any of the receivership cases say. They say it's common law, absolute immunity. And the only issue is, was the conduct within the scope of the authority of the receiver? We think what has been pled is all within the scope of the authority of the receiver, and simply taking things that he did pursuant to the appointment order and labeling them as conversion and civil theft is not enough to avoid the application of judicial immunity. Thank you.
Thank you, gentlemen. We appreciate your argument and perfect timing.